When microbiologist Carol Ann Bond found out her friend Merlinda Haynes was pregnant, she was ecstatic. That is, until she learned that the father was her husband. In a campaign of revenge, Bond smeared deadly chemicals on her friend's car, mailbox, and door handle 24 times. While Haynes only suffered a small burn on her thumb, if her newborn had come into contact with the chemicals, she likely would have died. This shocking case took a strange turn when Bond discovered that the chemicals used had been banned by an international treaty and a federal statute implementing the treaty. As a result, a federal district court sentenced Bond to 6 years in prison. Bond then challenged the application of the chemical weapons statute to her, invoking the 10th Amendment argument that her sentence interfered with powers reserved to the states. The Third Circuit Court of Appeals turned the case on its head. It argued that Bond had no right to challenge the federal government because she did not have standing. The judges claimed that in 10th Amendment cases such as this, only a state could argue that state sovereignty had been violated. In other words, the question was not if the government had overstepped its bounds, but if Bond could even challenge the government. Her case found its way to the Supreme Court. This bizarre 10th Amendment dispute, known as Bond versus the United States, would ultimately impact future cases of standing law. The 10th Amendment is one of the 10 amendments in the original Bill of Rights, ratified in 1791. This amendment states that any powers not delegated to the national government are reserved to the states and people, establishing the principle of federalism in dual spheres of government. Over the last 2 centuries, the Supreme Court has interpreted this amendment in various situations in order to balance power between the national and state governments. For example, in the 1824 case, Gibbons versus Ogden, the Supreme Court ruled that the national government has the power to regulate interstate commerce, or trade between states, while state governments have the power to regulate intrastate commerce, or trade within states. The 10th Amendment has been disputed with issues ranging from abortion to education to health care. One recent 10th Amendment issue that illustrates the limited powers of both the national and state governments is immigration enforcement. President Donald Trump has spoken repeatedly about forcing so-called sanctuary cities to comply with federal immigration law. However, he cannot simply order local governments to round up undocumented immigrants, even those who have committed serious crimes. This is because of the anti-commandeering doctrine, which holds that the federal government cannot force state and local governments to enforce federal law. This doctrine was established in the 1842 case Prigg versus Pennsylvania, but it has primarily become relevant over the last 2 decades. While the federal government cannot order local governments to enforce federal immigration law, it can issue subpoenas for criminal undocumented immigrants. This would force local governments to comply and keep these people in custody. If they refuse, they are not only failing to enforce federal law, but blatantly violating it. Still, state and local governments do have a measure of control over which federal statutes apply to them. But do individuals and corporations have that same power? This brings us back to the Bond case. In 2011, the Supreme Court unanimously decided that Carol Ann Bond did have standing to challenge the federal government. The ruling enables some private parties to initiate 10th Amendment challenges against the federal government without the assistance of the state. As stated by Justice Anthony Kennedy in the opinion of the court, states are not the sole intended beneficiaries of federalism. Thank you.